Welcome to The Explainer. Today, we're unpacking a really complex piece of proposed legislation, the UK's 2026 immigration bill. Based on some deep analysis of the bill's progression and the latest statements of changes, this proposed framework is, honestly, shaping up to be a total legislative obstacle course. Specifically, we're going to zero in on how this bill completely flips the script on appeal cases. If you're currently navigating an immigration appeal, you need to know this. The hurdles you have to clear are changing, and the bar, it's being set significantly higher.
Okay, let's dive right into this. Here is the roadmap of the macro and micro hurdles you'd face under these proposed rules. We're going to cover the new appeals authority, hurdles for Article 8, stricter dependency requirements, public funds and character tests, tougher deportation standards, and finally, some small wins and politics. So, starting with hurdle number 1, the new Immigration Appeals Authority, which is a massive structural shift.
This is a foundational change to how appeals will actually be handled. Currently, if you go to an immigration appeal, your case is decided by a legally trained judge, right? Well, under Part 1 of the new bill, the government is proposing something totally different, an independent immigration appeals authority. The big catch here, this new body would use non-qualified lay people. We're talking about individuals without formal legal backgrounds who will just be trained to make these massive decisions on immigration appeals. The source material compares it to how lay magistrates operate in magistrate courts, but applying that logic to something as incredibly complex as immigration law, that is a fundamental change in how evidence is weighed and appeals are judged.
And that brings us to a major point of friction highlighted in our source material. The government claims this new authority will be entirely independent, but the proposal indicates it's going to be physically based within the Home Office itself. The source raises a very specific and pretty glaring concern here. Isn't there an inherent contradiction in housing an independent appeals authority right inside the exact same government department that issues the initial visa refusals? It definitely begs the question of how much influence the Home Office might have over the training and ultimately the decision-making of these new lay judges. Moving on to Section 2, hurdles for Article 8 and the narrowing of family life. Shifting from the judges themselves to the actual laws they'll be enforcing, let's look at the specific legal barriers popping up for Article 8 claims, the right to private and family life. Central to all of this is the introduction of a brand new legal section, 117A. Right now, judges consider factors under Section 117B, but this new 117A introduces much stricter, binding factors that judges absolutely must consider when evaluating if someone's removal from the UK is appropriate. Basically, it severely limits a judge's discretion in an appeal case. And this brilliantly illustrates just how much that discretion is shrinking. Under current laws, say you've lived in the UK for a decade, you could go to court and argue, hey, my siblings are here, they support me, they're a core part of my established family life. And judges often give that real weight. But under the proposed 2026 bill, family life for these claims is strictly redefined. It's now just your spouse, your children, and your parents. Siblings, they are explicitly excluded. If you go to an appeal relying on the support of a brother or sister, the judge literally cannot give that relationship legal weight in an Article 8 claim anymore. Which brings us to Section 3, stricter dependency requirements, going beyond emotion. Because recognized family ties are shrinking so much, a lot of people might try to rely on extended family or friends. But navigating that dependency test, it's becoming a much, much steeper climb. It's morphing into a highly rigorous 3-step hurdle. Step 1, you have to prove the dependency goes way beyond just emotional or financial ties. Step 2, simply having a medical condition is no longer automatically enough. You have to demonstrate a constant, critical need for physical support that only this specific person can provide. And Step 3, you must prove this care is entirely unavailable if you are returned to your home country. Passing this ultra-strict test in an appeal setting is going to require mountains of thorough medical and circumstantial evidence. Up next is Section 4, Public Funds and Character, also known as the 117B tests. So the hurdles don't stop at family ties. The bill also heavily amends the tests dealing with the public interest. And it really makes you wonder, what exactly constitutes good character and public interest under these new rules? Well, as you'll see, the definitions are becoming incredibly subjective. They're starting to project future behavior rather than just looking at your present situation, which gives those new judges much broader grounds to simply refuse an appeal.
Let's break down those proposed 117B requirements. First up, true financial independence. This will now mean proving you won't rely on council housing or benefits after your visa is granted. The source outlines a pretty harsh hypothetical here. Imagine a judge refusing a family's appeal simply by projecting that because they previously received asylum support, they might need benefits again down the road. Then there's a new no NHS reliance clause. An elderly appellant with heavy medical needs could actually be refused purely to avoid burdening the taxpayer. Finally, the good character test demands incredibly strict cooperation. Imagine you missed a single reporting date during a 15-year stay. A judge could use that one missed date as proof of bad character to deny your entire appeal. Oh, and the wording around unlawful stays is changing drastically too. Currently, if you've been in the UK unlawfully for a long time, the law says a judge should give that little weight in your favor, but they still consider it. The new bill, it changes little weight to no weight. Whether you've been here 5 years or 15 years unlawfully, that time will provide absolutely zero positive weight in an appeal. Even just having a precarious legal status will now actively hurt family life claims.
So the crucial point here is how this impacts established routes, like the 7-year child rule under 117b6. Previously, if a kid lived in the UK for 7 years, you just had to prove it was unreasonable for them to leave. The new bill replaces that with near impossible standards. You literally must prove zero education is available in your home country. You have to prove specific integration difficulties, which, let's be real, is super hard if the child speaks the native language with their parents at home. And you must prove relocation would cause long-term negative health impacts. If your home country has functioning schools and hospitals, winning this appeal becomes incredibly difficult.
Moving to Section 5, tougher deportation standards and societal impact.
Now let's shift our focus to those facing deportation appeals under the revised Section 117C, because the barriers there are being massively heightened as well. The legal standard for fighting a deportation appeal is moving completely away from objective metrics. Previously, you had fixed sentencing thresholds, like whether your sentence was between 1 to 4 years, and that dictated what legal defenses you could use regarding family or private life. The new standard proposes giving judges the power to order deportation based on a highly subjective assessment of a crime's social impact. Essentially, the greater the perceived negative impact on society, the more likely a judge is to order deportation, regardless of the actual sentence length. Defenses are also being replaced with a blanket and much stricter exceptional circumstances test.
Finally, Section 6, small wins and politics. A glimmer of hope, maybe?
Okay, to release some of the tension from all these daunting proposed hurdles, let's look at a few positive legal updates that have actually been implemented and the broader political landscape that might dictate how this 2026 bill ultimately unfolds. A July 9th statement of changes actually introduced some immediate, tangible wins. First, under Appendix Suitability 13.1, if your administrative review is refused and you're placed on immigration bail, you now have a 14-day window to submit a new application, like a skilled worker visa, without being penalized as an overstayer. This is a massive relief for folks waiting in limbo. Second, an amendment to Graduate Visa Rule 9.4a means that babies born in the UK to graduate visa holders will now automatically be granted visas in line with their parents. It fixes a pretty glaring previous loophole that was leaving newborns without status.
But listen, the ultimate future of this 2026 bill depends entirely on the political climate, which the source notes has been, well, incredibly turbulent. According to the timeline in the analysis, Keir Starmer resigned as Labour leader on June 22nd. Literally, the very next day, a House of Lords committee published a report pushing back against the bill's strict measures. They argued that increasing qualifying periods to 10 years would harm lower-income families, and that applying it retrospectively would damage the UK's global reputation. Then, by July 17th, Andy Burnham was announced as the new Labour leader, promising a shift in political direction and a more centrist approach. Now, what's really interesting about this political shift is that it sparks an intense debate over transitional rules. Will migrants who are already in the UK on a 5-year route be grandfathered in? Or are they suddenly going to face these new tenure hurdles? The source highlights some major conflicting reports here. On one hand, leaks to the Times newspapers suggested that people who arrived post-2021 might be protected by transitional rules. However, Conservative leader Kami Badenoch has publicly criticized this idea, arguing that allowing transitional rules would essentially bypass the whole intent of the new bill and allow continued access to benefits. So, lots of political back and forth. As we wrap up this explainer, one thing is abundantly clear. The proposed 2026 immigration bill presents an absolutely grueling obstacle course for anyone facing an appeal.
I mean, from layperson judges to the elimination of sibling rights to ruthless new dependency and public funds tests, the legal hurdles are monumental. Yet, with a changing political guard, Andy Burnham forming a new cabinet, and key figures like Shabana Mahmood potentially shifting roles to chancellor, the final form of this bill really remains in flux. So, what do you think? Will these harsh realities be softened before they become law? Or is this strict new era of immigration appeals totally inevitable? It's a massive question, and one anyone navigating this system is going to have to watch very, very closely.